An election manifesto is a set of promises that a political party makes.
हिंदुस्तान से हम गरीबी को मिटा देंगे.
दुनिया की पहली 3 इकोनॉमीज में एक नाम भारत का होगा.
Once voted to power, can they be held accountable to fulfill their promises?
समाजवादी पार्टी की सरकार बनेगी और गरीब को 300 यूनिट दी जाएगी.
Can you sue a political party if they don't fulfill their election promises? How can this be enforced between the voters and their elected representatives? Is there a real legal enforceability case ever made out? Can you sue a political party if they don't fulfill their election promises? Unfortunately, no. An election manifesto is a set of promises that a political party makes to the electorate. Over the last few years, we've had whole host of political parties making promises from free bicycles to television to free bus rides to possibly work, sometimes pay without work and sometimes free ration. Now, based on these promises, a party is elected or rejected by the people. These promises form the core of why people would want to choose candidates of one political outfit over another. But once voted to power, can they be held accountable to fulfill their promises? How can this be enforced between the voters and their elected representatives? Is there a real legal enforceability case ever made out? Unfortunately, there is no penal provision if a political party fails to deliver on its promises. The Allahabad High Court had an occasion to consider this matter, and it held that an election manifesto released by a political party is simply a statement of such parties' policies, and those are not promises. It is not a set of promise that is enforceable. The court also clarified that in the absence of any legal provision in this country, under any statute whatsoever, that may expose a political outfit to penalties if they fail to fulfill their assurances, there is nothing that can be done. The Madras High Court expressed similar views in a different context. And yes, Supreme Court agrees. The top court asserted that promises made in manifestos are not legally binding, nor can such promises be treated to be corrupt practices under the Representation of People's Act. Non-fulfillment of election promise is not a crime. Making an election promise which possibly they don't want to fulfill is not corrupt practice. Neither can the registration of a political party be cancelled just because they have not fulfilled their promise, nor can they be penally prosecuted. Let alone penal prosecution, even proceedings for enforcement of those promises will not lie. Now, nothing stops a political party from promising the moon to the electorate and delivering nothing. The courts cannot and do not superintend what kind of promises can or cannot be made in an election manifesto. Various other high courts across the country have affirmed the view that a manifesto of a political party is simply a written statement declaring policy and the intentions of a political outfit, and is not legally binding whatsoever. An interesting view emanates from a judgment of the Delhi High Court. It sounds a jurisprudential analysis that could be used to hold elected representatives to account. That is based on the doctrine of promissory estoppel, a doctrine typically invoked against the state or its agencies when the government makes a promise or holds out an assurance and you rely on that promise to your detriment. At that event, you are entitled to enforce such a promise in a court of law and force the government to act in accordance with such promise. But that typically applies to the promise made by the executive or the government that is governing at that moment. The High Court of Delhi held that the Chief Minister would be accountable for his promises made during the COVID pandemic. The Chief Minister had made an announcement assuring that the rents of accommodation of daily wage laborers would be paid during the COVID-19 lockdown, and thereby asking such people not to leave the city and return to their native homes. The people complied, stayed back, but no rents were paid. The court directed the government to take steps for implementation of the promise within a period of 6 months. Though a division bench of the High Court in appeal stayed this judgment indeed offers a unique legal perspective towards holding elected representatives accountable for the promises they make. Now, what is the situation in the rest of the world? Unfortunately, enforceability of election manifestos does not seem to be a practical approach in most democratic countries across the world. For instance, the first problem would be of accountability itself. Who would be held accountable for non-enforcement of the manifesto? Would it be the political party, or would it be the government formed by the victorious members of such political party? Who within the political party is responsible? Is it the party president, or is it the committee that drafted the manifesto? Or even more stark, let us assume a case where a political party comes to power based on its promises and indeed genuinely attempts to enforce its manifesto and fulfill the promises contained in it, but fails to do so due to stiff resistance from the opposition or the opposing political parties. Now, will the leaders of the opposing political parties or the leader of the opposition be held accountable for creating an impediment whereby the government could not enforce the promises that it made in its manifestos? These are curious questions for which law, and at least common law, offers no answers. The case of Bhutan is an interesting experiment. The Election Commission of Bhutan, or the ECB as we know it, has done a truly commendable job in attempting to balance what we call the freedom to promise and at the same time restricting unrealistic promises. As a matter of democracy, political parties must be given the right to flex their muscles and make the promises that they will. At the same time, there should be some checks and balances to ensure that these promises are not totally unrealistic. The ECB has constituted an independent committee that holds month-long reviews of manifestos, and thereafter the election manifestos of political parties are approved by the ECB, which looks into the promises made and the practicality of such promises. Now, this ensures that no political party can make a promise that sways voters yet finds it difficult to implement. The Conservative government in the United Kingdom during 2017 to 2019 attempted to do something of this nature and submitted a petition before Parliament to make election manifestos legally binding. However, that did not materialize into a legal mandate. I don't think there will be any opposition to the idea of making political parties accountable. In an unruly election campaign, our law is well equipped to achieve objectives of a free, transparent and accountable election. Election manifestos in essence is a promise intentionally made by a political party, which makes it the promisor. When a voter casts his or her vote for a candidate set up by such party, the voter becomes the promisee. The voter chooses the party that has made the promise to his or her detriment of not choosing another candidate who actually may be better, but whose political party has made no such promises. When a political party is voted to power by virtue of its candidates being elected to form a majority essentially on the bedrock of the promises made, it naturally creates reciprocal obligations on the political party and the government so elected to fulfill those promises. Unfortunately, this obligation continues to prevail in the sphere of political morality alone and is not yet in the domain of legal enforceability.